Good morning, everyone. My name is Abril Valdes Siewert. I'm the immigrant rights attorney for the ACLU of Michigan. I have Russell Aberton, who is the treasurer of AILA Michigan and also runs Aberton Law, PLLC, out of Berkeley. It is our pleasure to be here today, giving you an update on immigration consequences of a criminal plea in the Trump era. And let's get started. So just a disclaimer for anyone listening, the information contained here is for educational purposes only. We're doing this as a service to the legal community and is not intended to be a substitute for legal advice or legal counsel. As of the date of recording this webinar, which is August 21st, 2019, we do have the most current legal developments that we have considered, but immigration law and the laws are changing, on a rapid basis, so we cannot confirm that the information is still going to be valid when you are seeing this webinar.
And if I can just add to that, that the information that we'll be providing is geared more towards criminal defense attorneys rather than immigration attorneys. And with that purpose in mind, we try to take a more conservative approach in how we view the potential immigration consequences of different convictions and criminal charges. If we were giving this presentation to immigration attorneys, we may encourage a more aggressive approach in terms of denying removability based on these same convictions.
Right. Thanks, Russell. So just a quick introduction of the voices that you are hearing today. Like I said, my name is Abril Valdes Siewert. I'm the immigrant rights attorney here at the ACLU of Michigan. I have a bachelor's degree from California State University, Los Angeles, and my JD from the University of Detroit Mercy School of Law. Mr. Aberton has founded Aberton Law, located in Berkeley, Michigan. He has received multiple awards from AILA, which is the American Immigration Lawyers Association, for litigation, mentoring, and volunteer work. He is very distinguished in the immigration community, and he earned his bachelor's degree from the University of Michigan as well as his JD. So what we're going to cover here today, we've broken it down to 4 different topics. We're going to cover immigration, the basics. As Russell mentioned, this is not for immigration attorneys, so we are keeping it very limited on the immigration practice. This is more targeted towards those who practice criminal defense or prosecutors who have to talk to criminal defense attorneys and have defendants who are immigrants. So immigration, the basics, what you need to comply with Padilla. 3, the categories of crimes, and 4, Michigan-specific crimes. So let's start with the basics. So for the purpose of our presentation, we want to go through the common immigration statuses, and that's because you can encounter any of these statuses when you are out in the community providing legal services. So the highest status that someone could have is U.S. citizenship, by birth, naturalization, or derivative. The second is lawful permanent residence, also known as green card holders or LPRs. There's also conditional lawful permanent residence, which is a 2-year green card that is obtained through marriage that then becomes a lawful permanent resident card. There are asylees and refugees. There's non-immigrants, which are students, tourists, temporary workers, and diplomats. A humanitarian basis of a status, which include deferred actions, such as the Deferred Action for Childhood Arrivals, which is DACA, parole and temporary protected status, which is TPS. And then a lot of people also fit under the none category, which is our undocumented immigrants, people who used to be on a non-immigrant visa but have overstayed, or people who have been ordered removed but haven't left. So other than U.S. citizenship, this status is fluid. You can see immigration status as being able to change, right? If somebody is placed into removal proceedings as a lawful permanent resident, they can become undocumented. if their green card is taken away from them and ordered removed. A non-immigrant, for example, a student can apply through work to have a different type of visa, and we won't get into those different categories, but the takeaway is that we need to know what type of status that person is in and whether that status can change in order to fully advise someone that is taking a criminal plea. Russell, is there anything else you want to add on this slide?
No, those cover the basic statuses or lack of statuses that individuals in the United States are likely to have.
So let's dive into what criminal convictions are under immigration law. And I provided the USC code and the INA code. The INA mirrors the USC, so you can check either version. But it is a conviction of any adjudication or admission of guilt with some form of punishment or restraint to liberty. So the key thing is the adjudication or admission, right? So we're talking about the fact pattern or what your client has said. One of the key things to keep in mind is that immigration, what criminal defense attorneys think of non-convictions, for example, work purposes or nursing licenses or things like that an employer won't see, does not apply to the federal government. Immigration will see and will consider these pleas as convictions. So for example, no contest or no low contender pleas, those are convictions under immigration law. Deferrals, 7411, 7694As, those are convictions. HIDA, conviction. Expungements, convictions. Drug court, for drug court, you have to plead guilty and then move into drug court. So because you're pleading guilty, it's a conviction. Pleas taken under advisement are also convictions. So we want to stay away from these. As good as they seem to a client, your client will be most likely concerned with being removed from the United States or putting their green card in jeopardy than not seeing a conviction for state purposes. Sentencing is also defined specifically for immigration law. So it's any period of confinement ordered by the court, regardless if suspended, deferred, or held in abeyance. This does not include probation. However, if your client violates probation and is sentenced afterwards for that probation violation and that crime, then that is considered a sentence. Depending on the statute, for immigration purposes, you have to consider whether the sentence is actually imposed or the possible term of imprisonment, or both could matter. And we'll get to this when we get to examples later on. Juvenile convictions, they are not convictions for immigration purposes unless it's charged as an adult charge or conviction. And I give you the case that you can read if you would like to on the slide. And so that's key, right? You want to look at that charge and you want to see if that charge was an adult charge or an adult conviction for that juvenile at that time. There's also a specific case out of Michigan where they refused to extend the Davison case for an offense that was taken under advisement under HIDA, which was a particular CSC case. So those are things to keep in mind.
And if I may, the difference here is a difference between a pure juvenile adjudication in a juvenile proceeding versus a HIDA adjudication that takes place in an adult court. And it still surprises me that we've had this definition of conviction for over 20 years and case law going back at least 10 to 15 years, concluding that HIDA adjudications are convictions for immigration purposes, yet non-citizen defendants continue to be advised to take a HIDA plea because it won't be a conviction and they won't be deported for it. And we'll get to this a little later, but that adjudications like that are often set aside because of ineffective assistance to counsel for failure to give proper advice as to the actual consequences of a HIDA adjudication for a non-citizen. So we can't stress enough that while for most people a HIDA adjudication might be a great deal, for a non-citizen, there's no functional difference between a height adjudication and actual conviction.
That's right. So we're going to get into some lingo, and just so everyone's aware, we are going to provide a toolkit and a resource guide that breaks all of this down. This is just the condensed version of everything we're going to talk about today, so you can see it, so you can get a feel for it before you dive into that resource guide. So inadmissibility versus removability. These are two different issues you have to consider for your specific client. So inadmissibility is the ability to re-enter the U.S. after departure or to apply to admission to enter. So for example, you have a client who has a green card and goes on a cruise, but before their cruise, they committed a crime, right? When they come back from their cruise at a port of entry, for example, at a Florida port of entry where their cruise ship boards and departs, there's going to be a CBP officer that's going to inspect whether they can come back in. And at that point, they can be determined inadmissible because of a crime that was committed in the United States, and they left and now are re-entering and asking for permission to re-enter the United States. So you want to be very much aware of whether your client is going to travel, has any travel plans, and potentially could become inadmissible. Removability, on the other hand, includes immigration or criminal issues arising after the admission to the U.S. that can result in the removal or loss of immigration status. So this is when the person is placed in removal proceedings, i.e. deportation proceedings, and the government is seeking to remove this person from the United States, so strip them of any immigration benefit or potential benefit, and then send them back to the country of origin. Anything you would like to add on admissibility and removability, Russell?
Just that later on in this presentation, we'll, in talking about specific types of convictions and types of offenses, the difference between the inadmissibility consequences and the removability or deportability consequences will become apparent, and you'll be able to see why this distinction can be important.
So pardons, there has been a lot of talk about pardons lately in the news about people with criminal convictions obtaining pardons in order to be able to apply for some kind of immigration status. And so we wanted to make a quick mention of pardons, that a full and unconditional gubernatorial pardon or a presidential pardon is the only way that someone can then apply for some type of immigration purposes, or can quote unquote like erase their criminal background. Is that correct, Russell, or am I reading that only the full pardon waives certain removal grounds?
It only waives those grounds that are listed, and that this became important for a group of individuals who had received pardons over the last couple of years for drug trafficking crimes. Those drug trafficking crimes trigger two separate deportation grounds, one for an aggravated felony and the other for the drug crime. The pardons cured or waived the aggravated felony deportation ground, but not the drug crime ground. And so those individuals remained subject to deportation and remained ineligible for relief from deportation, because even though the aggravated felony deportation ground was waived, it didn't eliminate the fact that there was previously an aggravated felony conviction, and that conviction had operated to bar them from obtaining relief. So pardons can be great when they're obtained, but there are significant limitations on their effectiveness to cure all immigration problems resulting from a conviction.
So when would you advise someone to seek out a pardon?
If someone is subject only to the deportation grounds that are listed, where they've been convicted of a crime involving moral turpitude, or they've been convicted of an aggravated felony that doesn't trigger other removal grounds, say like a theft offense or a fraud offense, then the pardon would likely eliminate that. I did have a client who had received a pardon for an offense, and because there were no other removal grounds, his removal proceedings were terminated. But if someone is still going to be subject to other deportation grounds or needs to apply for admission, then the usefulness of the pardon may be quite limited or non-existent. And at that point, the decision has to be made if it's worth devoting all the resources it takes to obtain a pardon, if it's not going to solve the problems you're hoping to solve.
Mm-hmm. Okay. So we want you to be aware of matter of Pickering. This was a case that went to the BIA, the Board of Immigration Appeals, in 2003. And what it stated is that a conviction vacated to avoid deportation remains a conviction for immigration purposes. So when pleas are reopened, or when you're negotiating pleas, it's my understanding that it can't be solely based on immigration consequences. There has to be more than that reason in order to request a plea, a different plea, or vacate a conviction. Is that your understanding of Pickering, Russell?
Yes, and I had litigated Pickering at the Sixth Circuit. The Sixth Circuit affirmed the general rule of Pickering, but reversed the Board of Immigration Appeals because they misapplied it to Pickering. And looking at the circumstances of that case, I think would highlight this distinction. If a court had vacated someone's conviction and gave as a reason in their order or in the transcripts, or the only basis listed in the motion was so the person would not be deported, then that remains a conviction for immigration purposes. But if in the order setting aside the conviction, the court lists as the reason for the setting it aside that the individual had received ineffective assistance of counsel, either because they didn't receive the required immigration advice on the consequences of the plea, or some other similar violation, then that conviction is no longer valid for immigration purposes because it was constitutionally defective. And in Pickering, which involved a Canadian conviction, it was set aside because it was entered in violation of the Canadian Constitution. Essentially, he didn't receive the requisite due process protections in the original proceedings. So it may seem at first glance that it's a distinction without a difference, but it is critical in seeking to set aside a conviction that the reason for it listed in the motion and the reason provided in the order and the reason given on the record is that it was a defective plea, that it wasn't knowing and voluntary, or there's some other error in the original underlying proceeding, and that it's not based on something that has occurred post-plea, like rehabilitation or
Russell, does
to
this
avoid
only
deportation.
apply? Does this only apply when you're vacating a conviction, or does it also apply to those criminal defense attorneys, for example, practicing in district court or circuit court, where they're negotiating a plea and their only leg to stand on is the immigration consequences of a plea? Does Pickering come in that circumstance where they want to avoid deportation per se, and that's what they are using as a tool to sway the prosecutor?
That is a different situation. And the Supreme Court in several cases, including the Padilla case that we're going to discuss later, but in several other cases, has made it clear that it's acceptable, in fact, it's required and best practice for not only a criminal defense attorney, but also a prosecutor and a state judge to take into account immigration consequences in plea negotiations and determining what a proper sentence would be. at least that's where we stand now. It's something that we could see either legislative change involving that or administrative changes by the Attorney General. While this is a little bit outside the scope of this presentation, generally in analyzing the immigration consequences of a conviction, we use what's called a categorical approach, where we focus only on the elements of the offense and not on the facts, either as admitted to or as alleged by the prosecutor or by a defendant. So if someone is charged with, and this is an extreme example, with murder, but then they plead guilty to trespass or they plead guilty to jaywalking, the fact that they may have been accused of killing someone or even admitted to killing someone wouldn't make them deportable for murder if the elements of a jaywalking offense don't include killing someone. And that's an extreme example, but that's, I think, highlights the importance of considering these immigration consequences in crafting a plea to find an acceptable alternate charge that would satisfy everyone involved in the criminal proceeding, but could avoid or minimize the immigration consequences.
Yeah,
and if I could just address
that. Sure,
yeah, just address two other points. There is a different standard right now that applies to sentence modifications. Some deportation consequences are based on the sentence. For example, a theft offense is an aggravated felony if it results in a sentence, including suspended jail time of 1 year or more. If someone does receive a sentence of 1 year or more on a theft offense, and right now goes back and gets resentenced to 364 days, that should be given effect and should be recognized for immigration purposes, regardless of the reason for the resentencing. However, and this is the second point, the Attorney General is considering both the matter of Pickering standard and the standard for sentence modification. So it's possible we could see some changes in both of these areas over the coming weeks or coming months, and it's important to monitor that and proceed accordingly. And in the interim, to take the most conservative approach in how these efforts to vacate a conviction or modify a sentence are handled, just in case the Attorney General comes up with a very unfriendly framework, at least from our perspective.
Yes, thanks for that, Russell. So that's a perfect segue of what you need to know to comply with Padilla. And as most of you who are going to be listening to this webinar, Padilla was a case that went to the Supreme Court in 2010 and established what an attorney's duty is in order to advise an immigration client. So we've set out a few bullets, and we will get into this, as Russell mentioned, but we want you to know that you need to advise your client on how to avoid being deportable, how to avoid immigration bars to relief from removal, which we will discuss, and advise regarding availability to travel, right? That's when we talk about admissibility, and also advise regarding naturalization, right? Could they become a citizen? And with that, would that get them into trouble if they have a prior offense? And just, as all of you know, how to avoid negative outcomes. So one of the key things that we want to mention is that Padilla is not just for defense counsel. When the court ruled, they said that deportation is an integral part of the penalty imposed on a non-citizen. So it also stated that informed consideration of possible deportation can only benefit both the state and non-citizen defendants during plea bargaining process. So this is what Russell was talking about, where you have to make it an issue, right? If my client pleads to this, they will be removed from the United States, right? It has to be part of the plea bargaining process, because by bringing the deportation consequences into this process, the defense and prosecution may well be able to reach an agreement that better satisfies the interest of both parties. sentencing is probation, for example, is for rehabilitative purposes, and so if there is something else that the defense attorney could negotiate with or for that does not involve deportation consequences, this is the key duty. And so for prosecutors out there listening, this is to say that you have to look at the best interest of the state and know that that working with an with a criminal defense counsel on getting to that goal is key. So how detailed must my advice be? I've heard a lot of defense attorneys say, well, I just say to any client, there may be removal consequences or there may be immigration consequences, and that's the blanket statement that is said in order to meet Padilla. We don't agree that that is the best practice. We think that the best practice is to use the penalty and benefit arguments discussed above during your plea and negotiations at sentencing. We consider that best practice is for a counsel to give specific advice as to what immigration consequences will result from a guilty plea. And we also think that there's ethical obligations as a negotiator for your client to have an informed decision of his or her plea. So let's get into ethical considerations. The preamble to the Michigan Rules of Professional Conduct says that as an advisor, a lawyer provides a client with informed understanding of the client's legal rights and obligations and explains their practical implications. So to me, that says that you have to inform your client of the consequences, of the specific consequences. And as a negotiator, you need to seek a result that is advantageous to your client. And so I don't think it would be considered advantageous for your client to plea to, for example, HIDA and then have to face deportation proceedings. The Michigan Rule 1.1, you should provide competent representation to your client. So that's where we get into, you need to find immigration legal counsel if you are not aware of the potential consequences. And so a lawyer shall not handle a legal matter that they are not competent to handle or handle legal matters without preparation adequate in the circumstances. Another ethical consideration is communication, right? Rule 1.4, the client should have sufficient information to participate intelligently in decisions. So a lot of the times, a client may be more concerned about the immigration consequences than they are of the actual criminal charge. Removal consequences are very serious. They tear families apart. And so your client needs to know whether that is going to be an issue that they are going to face. So what if my client is undocumented? A lot of the times I've heard defense attorneys say, well, my client is here illegally anyway, so why does it matter? And it matters, and I've written this slide especially because that's not a way of being a negotiator that you're going to get the best plea for your client as a criminal defense attorney, right? Someone who entered without inspection, EWI as it's colloquially called, or undocumented, you're going to face inadmissibility issues, right? They weren't admitted into the United States, but why should you worry about them? Well, first, being undocumented is a civil matter, right? Immigration law is civil law, not criminal, and so that's one thing that you need to consider. That they're not violating most of the time. They are not violating a criminal law by being in the United States undocumented, right? It's a civil matter. Also, they may be able to enter with inspection, right? They may be able to gain some type of status at some point in the future, and we want to be able to preserve that right? We don't want to have them be convicted to something that they could no longer be able to benefit from a change in the law or a petition or anything of that sort. Also, if they are caught and they're placed in removal proceedings, we want to be able to have some form of relief from them and preserve their ability to apply for deportation relief. And so you have to consider that undocumented clients deserve the same representation and the same diligence that you would provide anyone. And we still have DACA, the Deferred Action for Childhood Arrival, that at least until next year we still have people under DACA. And so what if my client has DACA? Well, with DACA, so these are, and I'm sure most of you know, these are children who were brought in when they were very young and are given work authorization, and work authorization allows them to have a driver's license and a work permit. It's a temporary status that can be taken away at any time, and it also has to be renewed. And so for someone to renew their status, they cannot have a conviction. So it can't be a conviction that's a significant misdemeanor, 3 misdemeanors, or a felony. For example, an OWI in the state of Michigan is considered a significant misdemeanor. Therefore, they would not be eligible to renew their DACA. So you want to be able to tell your client not to plea for something like that, because it may impact not only their driver's license, obviously, and the state purposes, but also their immigration status. Russell, do you want to talk about ineffective assistance of counsel claims? I know you brought it up earlier.
Yes, and this is where we get to the Padilla standard that, similar to all types of ineffective assistance of counsel claims, whether defense attorney has provided this ineffective assistance to a non-citizen defendant, it requires analysis of whether their representation fell below an objective standard of reasonableness, and whether there's a reasonable probability that but for their errors, the result would have been different. Most state courts and circuit courts had, prior to Padilla, viewed immigration consequences as collateral to a plea and not something that was required to be provided by a criminal defense attorney. Padilla recognized that although immigration proceedings are civil, the consequences, deportation, are as severe, maybe even more severe than what could flow typically from a conviction on like probation or a jail sentence, because deportation can be a lifetime banishment and separation from one's family. And therefore, the failure to provide immigration advice, accurate immigration advice, falls below this objective standard of reasonableness. At least in my area of practice, it seems that claims of ineffective assistance of counsel are the primary basis for motions to set aside a plea or a conviction, at least as when filed by a non-citizen defendant. And these may sometimes be followed up with a complaint to the Attorney Grievance Commission. The best way for criminal defense attorneys to protect themselves, and more importantly, the best way to ensure that their clients are making a fully knowing and understanding plea, is to make sure that these non-citizen defendants are advised on the specific immigration consequences and not just a general, there may be immigration consequence disclaimer. What I do when I'm asked to provide an analysis of the potential immigration consequences, I conduct a thorough review of someone's criminal history, so not just the current charges, but also other charges or convictions they might have in the past, as well as their immigration history here in the United States, and then also what their immigration future might be, especially for someone who doesn't already have a green card. What options might they be planning on pursuing in the future? And then provide advice as to the potential inadmissibility consequences, the potential removability consequences, the impact on potential relief and immigration benefits that could be available in the future, the possibility that they could be subject to immigration detention, including detention without bond, and other impacts on discretionary eligibility for relief. And I would imagine that many criminal defense attorneys are not fully versed in the intricacies of immigration law, and if that's the case, the way to protect yourself is to refer your client out to an immigration attorney who can conduct that review. And that's typically not a review that can be done during a 5-minute phone call right before a plea hearing. It requires a more detailed analysis, especially since immigration law changes. And while some of the advice and information we may be providing today is accurate as of today, it could change tomorrow, it could change a month from now, it could change a year from now, and everyone is coming with a different immigration history and a different immigration future, and this general information might not fit their situation.
All right, and now we're going to get into categories of crimes.
In this section, we will discuss some of the more common removal and inadmissibility classifications of crimes. The first one is what's called the crime of moral turpitude, or CIMT. It has a very vague definition, which is on the slide. It's conduct that's inherently base, vile, or depraved, and contrary to the accepted rules of morality, and the duties owed between the persons or to society in general. There's somewhat of a two-part analysis as to whether the conduct is reprehensible and the degree of scienter that the person has to act with, whether it's a specific intent crime, whether it requires deliberateness or recklessness. To some extent, the more serious the crime, the lower degree of scienter is required. There's some concern that this is an unconstitutionally vague classification of crimes. So far, the courts have more or less rejected that argument, and it's for now and until something changes, it's best to take a conservative approach and assume that a crime that could fit within this classification is. With a broad definition like this, it really requires a case-by-case analysis as to whether a particular offense does trigger or does fall within this CIMT classification. The courts have held in the past that theft or retail fraud involves CIMT or is a CIMT. While simple assault generally is not a CIMT, if there's an aggravating factor, like an aggravated assault, assault with a weapon, assault against a spouse or family member, assault against a police officer, that can be a CIMT. Offenses involving fraud or deceit or sex offenses can also. Though for any of these, it depends on the elements of the offense. If there's no scienter as to the age of the complaining witness or the victim in a sex offense, or if an assault offense involves very de minimis conduct, then there may be an argument that's not a CIMT. But in performing that analysis, it requires a detailed review of the case law that's in place at the time of that analysis. CIMTs carry a full basket of immigration consequences, and the consequences depend on whether someone is subject to deportation or inadmissibility. And so that's where that distinction we discussed earlier in this presentation, where you can see it in practice. A single CIMT that's committed within 5 years of someone's admission, where the CIMT carries a statutory maximum of 1 year or more, regardless of the actual sentence imposed, that triggers deportation. For example, if someone was admitted to the United States 20 years ago and they're convicted of a single CIMT today, regardless of the maximum or the sentence, that would not trigger deportation under this provision, though it may carry other consequences. A single CIMT does trigger inadmissibility unless it falls within what's called the petty offense exception, which means it's punishable by 1 year or less in jail and resulted in a jail sentence of 6 months or less. So going back to that hypothetical I just mentioned, someone that was admitted to the U.S. over 20 years ago and is convicted of a CIMT with let's say a 5-year statutory maximum today, they might not be deportable, but the next time they travel outside the United States, they could be denied admission and placed in deportation proceedings and potentially detained for the duration of those proceedings. So if someone falls within this example, the advice given to them should reflect that they might avoid deportation, but they should not travel outside the United States. And similarly, if let's say they're here as a non-immigrant, as a student or worker, like an H-1B or some other non-immigrant temporary worker category, but they've been here for more than 5 years, and they're hoping to apply for a green card in the future, this single CIMT could potentially bar them from getting a green card, and that advice would also have to be given to them. If someone is convicted of multiple CIMTs, that triggers both removability, meaning deportation, and inadmissibility. That's why advice as to the potential immigration consequences has to take into account someone's criminal history as well as their immigration history, and in addition to the current charges. CIMTs can trigger what's called mandatory detention, meaning that someone can be detained without bond for the duration of their removal proceedings, even if they're a permanent resident, and even if they're eligible for relief from removal. The Supreme Court has held that mandatory detention is constitutional, and so that's another consequence that would have to be discussed with someone facing this charge. CIMTs can also render someone ineligible for relief from removal or ineligible for certain immigration benefits, and can delay their eligibility for naturalization because it could prevent them from showing the requisite good moral character for U.S. citizenship. So even permanent residents that's not going to be deportable as a result of a conviction for a CIMT, if they want to or need to apply for citizenship, this would delay that by anywhere from 3 to 5 years or perhaps longer. Next slide. Another category, another classification of immigration consequences for convictions are aggravated felonies. Even though they're called aggravated felonies, they don't have to be aggravated and they don't have to be felonies. Someone who's convicted of a misdemeanor offense or even a simple shoplifting offense could be an aggravated felon. And so you can't just look at how something's classified under state law. Even if it's a state misdemeanor, it can still be an aggravated felony. Some common ones, and there are very many of these. Some common ones are crimes of violence or theft offenses that result in a sentence of 1 year or more, and this includes suspended jail time. So someone who's convicted of retail fraud with a 365-day suspended sentence, they're an aggravated felon. 364-day suspended sentence or 364 days in jail, since that's less than a year, they're not an aggravated felon. Drug trafficking is an aggravated felony. Fraud or deceit with a loss to a victim of at least $10,000, that's an aggravated felony. Sexual abuse of a minor, that's an aggravated felony, even if it's a misdemeanor offense. On sexual abuse of a minor, because the age of the victim has to be an element of the offense, sexual assault under 750.520G, because the age of a victim is not an element of that offense, that may avoid that aggravated felony ground, though it may carry other immigration consequences.
So Russell, with fraud or deceit, of a quick question, of the loss of a victim of at least $10,000. For example, in Michigan, we have uttering and publishing, right, which is check fraud. If the person, if the victim was defrauded of less than $10,000, this person is not considered an aggravated felon, but they can still fall under a crime of moral turpitude, correct?
Exactly. And a conviction can fall within multiple classifications and carry multiple, or be subject to multiple deportation or inadmissibility grounds. And that's a good point on fraud or deceit, that the loss to the victim has to be under $10,000. We'd mentioned earlier the categorical approach that's applied that focuses on the elements of the offense. The Supreme Court has held that the loss to the victim is not analyzed under a categorical approach, instead analyzed under what's called a circumstance-specific approach, meaning that an adjudicator, an immigration judge, can look beyond the record of conviction and beyond the elements of the offense to determine the actual loss. However, that loss has to be tied to the count of conviction. And that allows a criminal defense attorney to engage in some creative plea negotiations where, for example, if someone is charged with multiple counts of fraud and some of them are under 10,000 and some are over 10,000, or maybe they total 10,000 but each one is under 10,000, pleading guilty to a single count and making the record of conviction clear that the amount of loss is under $10,000 could avoid an aggravated felony charge, though not necessarily a CIMT charge. And in crafting that, the record of conviction would have to be absolutely clear, that in the indictment or the superseding information would have to list a loss under $10,000, and that would have to be part of the plea colloquy as well as the judgment and sentence. All of the aggravated felony grounds, and there are over 25 of them, can be found at 8 U.S.C. 1101, Section 843. So aggravated felonies carry extremely serious, sometimes fatal immigration consequences. They subject a non-citizen, including permanent residents, to mandatory detention, and that means detention without any right to bond. There's no possibility of bond. Aggravated felons are ineligible for most forms of relief from removal, including asylum, a type of waiver called cancellation of removal. It creates a permanent ineligibility for a waiver of inadmissibility for most non-citizens, subject to very narrow exceptions. The lawful permanent resident convicted of an aggravated felon is ineligible for naturalization. They're ineligible, non-citizens are ineligible for voluntary departure. And for someone who's convicted of an aggravated felony and deported and illegally re-enters the U.S., they're subject to enhanced sentencing and can be in prison for up to 20 years. Also, individuals who are not lawful permanent residents, if they're convicted of an aggravated felony, they can be subjected to summary removal, which means that even if they're eligible for some type of relief from removal, they could be removed without a hearing before a judge.
And Russell, can you just quickly give the definition of voluntary departure, since it is a term of art under immigration law?
Voluntary departure allows someone to leave voluntarily in lieu of being ordered removed. But it has to be a specific thing that's granted by an immigration judge. If someone is ordered removed or ordered deported and buys their own ticket or just drives themselves across the border and leaves, they might be leaving voluntarily, but they're not leaving with voluntary departure. An immigration judge has to actually grant that. And if someone is ordered removed and leaves under the removal order, they're subject to a ground of inadmissibility that could be 5 or 10 or 20 years or longer. If someone leaves under voluntary departure, they avoid that removal order bar on re-entering the United States if they would otherwise qualify for a visa to return, though they may be subject to different bars for their criminal history or their immigration history, but they would at least avoid a removal order being on their record. The next type of offense that we'll discuss is a crime of violence. A crime of violence is resulting in a sentence of 1 year, including suspended jail time. That's an aggravated felony. What's a crime of violence, and that's a term of art, that definition is imported from the criminal law at 18 U.S.C. 16. Under 16A, if an offense has as an element the use, attempted use, or threatened use of physical force against the person or property of another, that would be a crime of violence. The second prong of that definition, which is the residual clause, 16b, that's been found to be unconstitutionally vague in the case that's cited there. And the Supreme Court has affirmed the Sixth Circuit and held that 16b is unconstitutionally vague. So right now, we just have to look at 16a to determine whether an offense is an aggravated felony, and that's focused purely on the elements of the offense. Because it's focused purely on the elements of the offense, it generally doesn't include a simple assault, because a simple assault in Michigan doesn't require an actual touching or causing suffering or pain. That a de minimis act like spitting at someone or any sort of unwanted or non-consensual touching, even with minimal force, can meet the definition of an assault under state law. The aggravated versions of assault, like assault with a dangerous weapon, that has been found to be a crime of violence. It's important also to note that a felony firearm can be a crime of violence if the underlying crime that makes it a felony firearm is itself a crime of violence. So if someone is convicted of using a firearm during the commission of an assault, of an aggravated assault or an assault with a dangerous weapon, that can be a crime of violence. And because a felony firearm charge carries a minimum 2-year sentence or a mandatory 2-year sentence, then all of a sudden the person is subject to an aggravated felony removal ground.
So a felony firearm alone is not a crime of violence without an underlying crime.
Right, if the underlying crime itself is not a crime of violence. So let's say someone was, and I don't know all the felonies, but let's say someone was convicted of a crime of, or a felony firearm where the underlying felony is felony jaywalking, whatever that might be, then that would not be a crime of violence. But if the underlying felony is an assault, or if it's a home invasion, or a theft offense, or anything that would itself be an aggravated felony, then the felony firearm would also, because the felony firearm has as an element the elements of the underlying offense. And the Sixth Circuit has suggested that a defense attorney who fails to advise a non-citizen defendant about that consequence in the context of a felony firearm may be providing ineffective assistance of counsel. And I bring that up and put that on the slide because I've now seen that twice within the last year or two, and it may signify something that the immigration authorities are looking for in charging someone with deportation. Next slide. A crime of violence, so a crime that meets the 18 U.S.C. 16a definition, that's committed against a protected person, so like in the domestic violence context, that triggers a separate removal ground for a crime of domestic violence. So under that, a simple assault would, or a simple domestic violence assault under 750.81 would not be a crime of domestic violence because the minimum conduct necessary to violate the statute, it doesn't, like I said, doesn't require actual touching or the causing of suffering or pain. That a de minimis contact or something like spitting can violate that. But if the assault is a higher degree of assault, like an aggravated assault or an assault with a dangerous weapon, or say a home invasion, that can trigger the domestic violence removal ground.
So
although we've been talking about the categorical, I'm sorry, go on.
I wanted to ask you a question about if someone is being charged with domestic violence, but pleads to a non-domestic violence assault, can they avoid removal grounds then?
And you anticipated what I was going to cover, and the answer to that is no. Although the categorical approach applies to determine whether it's a crime of violence, whether the elements of the offense meet 18 U.S.C. 16a, the part referring to the victim, whether it's been committed against a protected person, the courts have and the agency use a circumstance-specific approach So if the victim is identified or the victim is a protected person, even if the conviction's not under a domestic violence statute, it could still be a crime of violence. So, for example, if someone is convicted of assault with a dangerous weapon, and the victim is the person's spouse or someone that they had cohabitated with in the past, then that's a domestic violence offense, and the person can be subject to deportation for a crime of domestic violence, even though they weren't convicted under what Michigan would call a domestic violence statute.
Could you walk us through how this applies with criminal sexual conduct offenses?
Yes, for criminal sexual conduct offenses, those can carry different types of removal consequences. If it's a CSC against a minor, then that will be an aggravated felony for sexual abuse of a minor. But that conviction has to occur under the CSC prong where the age of the victim and the age difference between the victim and the perpetrator are elements of the offense. If it's under the force or coercion prong, it may not be sexual abuse of a minor, but it could be a crime of violence if the elements of a CSC offense match up to 18 U.S.C. 16A. And if it's force or coercion against someone who's a protected person, then that could also be a crime of domestic violence. But if it's force or coercion against someone who's a minor, it may not be a sexual abuse of a minor offense because the age of the victim is not an element. Rather, the element is the force or coercion. And then if the person has a sentence of less than a year, it wouldn't be an aggravated felony, although it may be a CIMT. So again, this is where creative plea negotiations can be extremely beneficial, both to the defendant and also to the prosecutor, where the prosecutor can still obtain the type of conviction they want, a CSC conviction, but the defendant could plead to a sub-prong of a statute that carries less or maybe no immigration consequences. And now we'll get into some other common removal grounds. Drug crimes. There are several different consequences that can flow from a drug offense. If the government has reason to believe that someone is a drug trafficker, they are permanently inadmissible to the United States. Reason to believe does not require a conviction. It may not even require a criminal charge. And that creates a permanent ground. That would apply to someone who's applying to re-enter the United States after traveling abroad. It would apply to someone who's trying to enter the United States for the first time. It could apply to someone who's in the United States and is applying to adjust their status to permanent resident status, so they're applying for a green card. Any drug crime, a conviction for any drug crime, triggers a permanent inadmissibility bar. Whether it's a misdemeanor or felony, doesn't matter. The only drug crime that can be waived is a single conviction for personal possession of less than 30 grams of marijuana. Multiple marijuana convictions, that's a permanent unwaivable bar. Misdemeanor convictions for possessing any other kind of drug, that's a permanent ground of inadmissibility and can't be waived. A conviction for any drug crime also triggers deportation regardless of how long the person has been in the United States. The only exception for this is a single conviction for personal possession of less than 30 grams of marijuana. But because that would make the person inadmissible, that person should not travel. So a permanent resident who is charged for the first and only time with marijuana possession and pleads guilty to that might not be deportable, but they absolutely have to be advised to never travel until after they become a U.S. citizen, because if they do travel, they'll be placed in deportation proceedings and could be detained and may not be eligible for relief from removal, depending on their immigration history. And so they may be looking at automatic exclusion and deportation and an inability to re-enter the United States. Even though medical marijuana and other marijuana-related activities are legal under state law, they can still carry serious immigration consequences because these are still unlawful for federal purposes. This can include the denial of naturalization or the denial of admission. For example, and I've seen this, if someone, an elderly person, was prescribed medical marijuana as they were going through cancer treatment and then applies for citizenship, they will be denied because they cannot show good moral character because they've been engaged in unlawful drug activities, unlawful under federal law, even though legal under Michigan law. If someone is involved in legal marijuana activities like investing in legal grow operations or legal dispensaries, they can be denied admission when they try to enter the United States, or if they travel abroad and try to re-enter the United States. So if someone is advising non-citizens about whether they can or how they can be involved in these new and growing marijuana businesses, these immigration consequences have to be included in that discussion. Other removal grounds include firearms. Firearms trigger deportation or removability, but not inadmissibility. So someone who has been convicted of a firearms offense won't be denied entry when they travel abroad, but they can be placed in deportation proceedings. This includes even misdemeanor firearms offenses, anything relating to use or possession or other related activities concerning firearms. Carrying a concealed weapon, for example, but even some licensing related offenses could also trigger that. Domestic violence, we've already discussed. Stalking, violation of a protection order, even if it's a civil violation, can trigger deportation. Also, a crime of child abuse can trigger deportation. The failure to register as a sex offender, someone who's convicted of falsely claiming U.S. citizenship, or someone who falsely claims U.S. citizenship, even if they're not convicted of that, can be subject to deportation and permanent inadmissibility. There's terrorist-related grounds as well.
So, Russell, question about protective orders. I've seen two types of protective orders. I've seen it in family court where somebody obtains a personal protection order, a PPO, and those violations are civil violations. But I've also seen in criminal cases where domestic violence occurs, where the judge sets a no contact order. In either of those cases, does this apply?
Yes. If someone is found by a judge to have violated a protection order, that can carry deportation consequences, even if the order was entered in the context of a civil proceeding, and the violation was determined or was adjudicated as part of a civil proceeding.
Or if it was indicated as part of their criminal proceeding and they were told to stay away from that person, but they did not.
Correct. If they violated it, there has to be a violation, and then there has to be a judicial finding of the violation. So the statute is written, the immigration statute is written very broadly, and it applies to anyone who is enjoined under a protection order and for whom the court has determined has engaged in conduct that violates the portion of a protection order that involves protection against credible threats of violence or repeated harassment or bodily injury to the person or persons for whom the protection order was issued. So that doesn't require an actual conviction. It just requires some sort of contempt determination that's been entered or similar order.
Thank you.
And next slide. While these aren't technically criminal-ish grounds, the health-related grounds of inadmissibility do bear a relationship to certain criminal activity. So someone can be found to be inadmissible to the United States if they have a physical or mental disorder that poses a threat to the property, safety, or welfare of themselves or to others. Where this can come up in the immigration context is alcohol-related offenses, that these have to be when someone is applying for admission to the U.S., so they're applying for a visa out at a U.S. consulate abroad, or if they are applying for a green card from within the United States, they may need to be referred to a panel physician, so a U.S. State Department approved physician abroad, or a designated civil surgeon within the United States for an assessment as to whether they have a problem with alcohol. And drunk driving or alcohol-related driving offense can trigger that referral and result in inadmissibility. Also, drug abusers or drug addicts can be inadmissible on health-related grounds. If someone during a visa interview or during a medical exam related that's required as part of the visa process admits to using drugs, they could be deemed inadmissible for a period of 1 year or more, during which time they would have to show that they are clean through things like drug testing before they could overcome that inadmissibility ground. What we've been seeing more and more of over the last several years is that if someone is even just charged with an alcohol-related driving offense, even if there's no conviction or the conviction is for something other than alcohol-related driving offense, it can lead to what's called a prudential revocation of their non-immigrant visa. For example, if someone is here as an F1 non-immigrant student or as an H-1B worker and they get arrested or charged with operating under the influence, the State Department may discover that or may learn about that very quickly within perhaps days of the arrest and revoke their visa, which would then mean that the next time they travel abroad, they would not be able to re-enter the United States unless they obtain a new visa, which may require an alcohol assessment and a referral to a panel physician for that assessment in order for them to overcome that and get a new visa.
Right, and I would like to add that that's why it's crucial to ask, what type of immigration status your client has, because we are a border state, and a lot of the people who I have seen the impact of this have, for example, a TN visa, where they're coming in and out of Mexico or in and out of Canada, and while in Michigan, they have an alcohol-related driving offense. And then once they go renew or once they go visit, that visa has been revoked.
And to the extent that these are triggered by the mere arrest or charge, that means there's maybe nothing a criminal defense attorney can do other than to turn back the clock and tell someone not to get arrested. But once that revocation occurs, it's still important to try to negotiate a plea that could leave open the possibility of the person obtaining a new visa in the future.
So now we're going to get into Michigan-specific crimes. We have updated the Crimmigration chart that was last updated in 2007 to reflect current law, and we will be providing that as part of this presentation, but we wanted to get into specific examples of crimes in Michigan that we significantly encounter, or that we have been told criminal defense attorneys encounter, just so we can take what we've learned so far and apply it here.
Thank you. And in reviewing the chart, it's important to keep in mind that that chart was completed based on a current understanding of immigration law and how it's being applied to those charges or those convictions and those statutes. But immigration law frequently changes, and when it does, those changes can be applied retroactively to past convictions and past conduct and past acts. And whenever confronted with a situation, in addition to using that chart, to use it as just a starting point and to conduct up-to-date research and review to make sure that that information on that is accurate and that that information will fit with your client's specific situation. The first area that we're going to cover in terms of Michigan crimes are some drug crimes, and to look at the difference in the context of marijuana, the difference between delivery or possession with intent to distribute versus simple possession, because there are big differences in how those offenses are classified. Next slide. With marijuana, and we've discussed some of this earlier in this presentation, a single conviction for simple possession of less than 30 grams will make a non-citizen inadmissible if they're seeking to re-enter the U.S. or apply for LPR, green card status, but it will not make them deportable if they never leave the United States. This can include convictions that have been expunged or dismissed. Delivery or manufacture or possession with the intent to deliver of most other drugs are aggravated felonies because there's a trafficking element. With marijuana, it's generally accepted that a conviction under 333.7401, section D3, is not a drug trafficking aggravated felony because it includes social sharing for no remuneration. And the reason for this is that there's a safety valve under federal law where a conviction for marijuana is classified as a misdemeanor instead of a felony if there's social sharing for no remuneration. And because the minimum conduct necessary to violate this Michigan statute includes individuals who are each entitled to lawfully possess or use marijuana, sharing it with each other in violation of the law. And under the categorical approach, we look at the minimum conduct. This statute's not an aggravated felony, or has been held not to be an aggravated felony. However, convictions under paragraph or subparagraph 1 or 2 could be an aggravated felony because there's a minimum quantity element of 5 kilograms or more in those provisions, where under paragraph 3, there's no minimum quantity that has to be proven by the prosecutor. However, a conviction, even under section 3, could still trigger inadmissibility if the government has reason to believe that someone's a drug trafficker, because there's room for the immigration officer to look beyond the elements of the offense and to look at things like the police report or someone's admission, either at the time of the arrest or at the time they're seeking admission to the United States.
So hypothetically, if a defense attorney has the option to plea their client to delivery with intent to distribute versus possession, what do you as an immigration attorney advise or prefer for a client who for example, has a green card or has no status?
For someone who has a green card, a possession offense would still be preferable to a conviction for manufacturing, delivering, or possessing with intent to deliver. And it should be indicated in the record of conviction, like the plea colloquy, that the person was possessing less than 30 grams, as opposed to leaving the quantity undefined, or even worse, the worst thing would be to have the quantity defined as more than 30 grams, because if that's indicated, then the person's been convicted of something that doesn't fall within this immigration safety valve. For someone who has no status in the United States, any type of drug conviction can carry significant consequences, though possession may be preferable to a conviction under 7401. And if someone has to be convicted under 7401 because there's just no way to negotiate a different type of plea, then Section 3 would be better than Section 1 or 2. And a conviction for marijuana under Section 3 or a conviction for possession of marijuana would be better than a conviction for any other type of drug, because there is some wiggle room where someone can either avoid deportation or obtain a waiver if they are deportable or inadmissible for marijuana, whereas for other drugs that might not be available to them. Though again, because there's so many different types of statuses and immigration histories and plans for someone's immigration future, it really requires a case-by-case analysis as to what the best outcome would be for that person.
Mm-hmm. And so the next slide, we get into the lawful uses of marijuana, which we know is now legal in the state of Michigan, but you did mention that regardless if someone has an MMA card, they may be ineligible for naturalization because they won't be able to show the required good moral character, as it is still a federal crime. Have you seen the potential inadmissibility and how it plays into admitting the use of marijuana?
Yes, and that's something that's becoming more and more of a problem for either people who are outside the United States who want to invest in marijuana businesses that are legal under state law, in whether it's Michigan or Colorado or elsewhere, or Canadians who are involved in the legal marijuana industry there and are seeking to enter the United States. It can be a very nuanced analysis as to whether they're admissible or not. I've seen officers and judges, immigration judges and immigration officers ask if someone uses marijuana legally, if they've ever smoked, if they have a medical marijuana card. And depending on the situation, sometimes it can be overcome if the person can satisfactorily demonstrate that they won't use medical marijuana anymore and that they've found other ways to treat whatever they were treating before. I would also be concerned if even if the non-citizen's not involved in any of these activities, but they have a spouse who grows marijuana for their own medical marijuana needs, that could somehow be attributed to the non-citizen. And if the non-citizen waters the plants, for example, then they could somehow be found to be involved in activities that, while legal under state law, would be illegal under federal law and would carry significant immigration consequences.
Okay.
Next slide. Disorderly person is often viewed as a safe harbor for immigration purposes because the elements of disorderly person generally don't fall within any of these immigration classifications that we've discussed. I would be wary of some of these subsections within the disorderly person statute that relate to activities that themselves could carry immigration consequences or don't sound that good to an officer or judge. For example, anything relating to prostitution should be avoided. And since there are multiple subsections, there should be some room to negotiate a plea to maybe the safest and least bad of those provisions. It's also important to note that for inadmissibility purposes, meaning if someone's applying for admission to the U.S. or if they're applying for a green card or if they're applying for some sort of discretionary benefit, even if the disorderly person conviction doesn't bar them from that relief or if it doesn't trigger deportation on its own, anytime there's an application for something that's discretionary, the officer has an opportunity to look behind the curtain, look at the police report, ask the individual questions about what they were doing, and the cleaner the record can be, the better it will be as someone navigates those processes. Next slide. Home invasion can be an aggravated felony as a crime of violence or as a burglary offense or as a theft offense if it results in a sentence of 1 year or more, including suspended jail time. It can also be a CIMT. We have some tips here for plea negotiations. Trespass has been found in unpublished agency decisions that it doesn't carry removal consequences. Those decisions are unpublished, so they're not binding, and that law can change, but to the extent that someone's looking for a safe harbor, that might be one. Also, entering without breaking has been found in an unpublished agency decision to not be a CIMT. So entering without permission, entering without breaking under 750.115, Section 1. And the reason that's not a CIMT because it doesn't require an intent to commit a turpitudinous act. So that's something to keep in mind in going through plea negotiations. Next slide. Retail fraud, so shoplifting, that's a CIMT. If the sentence is 1 year or more, including suspended jail time, it's also an aggravated felony theft offense. Multiple retail fraud convictions make someone deportable and inadmissible to the United States. A single conviction under Retail Fraud 1 or Retail Fraud 2, because those have statutory maximums of 1 year or more, are deportable offenses if they're committed within 5 years of someone's admission to the United States. A single conviction for Retail Fraud 3, because it's a 90-day misdemeanor, that doesn't make someone deportable or inadmissible because the maximum sentence is less than 1 year. A single conviction for Retail Fraud 2 would not make someone inadmissible if it carries a sentence of 6 months or less. To go back to what we were talking a few slides ago, disorderly person, maybe a preferable plea outcome here, or possibly even something like trespass or entering without permission as well, to the extent that there's a willingness on the part of the prosecutor to negotiate. Next slide. And again, domestic violence under 750.81. Those are unlikely to be CIMTs or aggravated felonies. A plea that's handled under Michigan's domestic violence diversion statute is still a conviction for immigration purposes. It's important to note that even avoiding a conviction under 750.81 under the domestic violence prongs and just pleading to a simple assault, to the extent that that could be a crime of violence, and that would be a crime of domestic violence, even if it's not a state domestic violence offense. A conviction that does fall within the classification of a crime of violence committed against a protected person makes someone deportable. It would only make someone inadmissible if it's also a CIMT and would otherwise trigger inadmissibility because it's not a petty offense.
So we developed this checklist to sum up everything that we've discussed. We know that it's a lot of information to digest, and this is why we wanted to record, have a recording for people to go back to and re-listen to. But we also wanted to provide a concise, check the box to see if you're covering everything when you are interviewing your client. And we understand a lot of people have court-appointed work, and the time spent with a client is not ideal. But these are some of the questions that you want to ask yourself and your client to make sure that you are meeting Padilla and doing everything you possibly can to avoid any negative immigration consequences for your client. So you want to know your client's immigration status. If they say, I have a green card, you may want to know if they want to apply for naturalization coming up. You may want to know if they have travel plans. If they say, yeah, I'm legal, you want to know what does that mean, right? Does it mean that you're on a temporary visa? Does it mean that you're here as a tourist? Does it mean any of those different statuses? You need to ask more than just, are you a U.S. citizen, yes or no? Is there inadmissibility consequences, right? Does your client want to travel in the near future? And are they going to have issues returning? Deportability. Is pleading to something going to trigger ICE coming to pick them up in the near future? And is the crime considered an aggravated felony? Will the crime result in mandatory detention by ICE if they're held? And mandatory detention is sometimes a bigger deal to clients than anything else, because you know, they know the crime will result in a state conviction, but they weren't aware that they were never going to be able to bond out of an immigration facility. So we want to be able to tell clients that that may be a possibility. Good moral character bars, like we said, in order to apply for naturalization, you need to prove that you have good moral character. Is your plea or your conviction going to have consequences to that? And lastly, is the offense considered a crime of violence, which is the definitions that we went through on that. And so resources, we're here to help. Like I said, we will be providing you with a Michigan-specific Crimmigration chart that has been updated and a resource guide. Obviously, this is not the end-all, be-all of your search for answers, and this webinar is not intended for that purpose. But there are different resources out there. We have created the State Bar of Michigan Immigration Law section that will go live as of October 1st. It will have a specific landing page on the State Bar of Michigan's webpage. It will have contact to immigration attorneys there. Russell and I will both be on there, so you can definitely contact us that way. AILA Michigan, the American Immigration Lawyers Association, has a chapter in Michigan that we are also involved in that can also help. We've provided the website there. If you need referrals or want to bounce questions off of any immigration attorney in the area, we can guide you through that. And lastly, here is our contact information. I would like to thank Russell for your time and dedication to this work. And thank you to the ACLU and AILA Michigan chapter for providing us the resources to be able to do this today. Any closing words, Russell?
And thank you very much for organizing this and putting this together. The analysis that we've been discussing and the advice that's given to your clients, that has to be done in the beginning. That has to be the first thing that's done, not as you're walking in for a plea hearing, because it's a very intensive analysis, and it's of utmost and perhaps the most importance to a non-citizen defendant. A difference between a few months of probation or some jail time may not matter as much as someone's ability to stay in the United States and be here with their family, where the alternative is they can never come here or they can never come back here for the rest of their lives. And having that information can help with plea negotiations, because it could allow someone to plead to something that might be a worse offense under state law, but a better offense for immigration purposes. And having that awareness and having those tools can allow a criminal defense attorney to better represent their non-citizen clients and achieve a result that's in their best long-term interests.
All right. Well, thanks again, and we hope that this was useful for everyone listening. Thanks, Russell.
Thank you.